Hi, this is Attorney Christie from the Christie Law Firm, and I'm here in our second installment regarding substantiation hearings. And as we talked about before with DCF, when they do an investigation and they make a finding, you have a right to appeal that particular finding. And so in our previous video, we talked about how that starts with the substantiation. And today I want to talk to you about the actual substantiation hearing and what to expect. So as I said before, you should be getting notice from DCF as to the day and time of the substantiation hearing. They're typically about 2.5 hours long, maybe up to 3. They cut it off at 3, but if they need more time and there's another day, they will continue it. So typically it starts with the notice, and in the past, before the quarantine, the actual hearing would be held at the DCF office that was responsible for the investigation. A hearing officer will come from central office. They'll set up the room, and once you arrive and you check in, go through security, they will bring you into the room and you will find the hearing officer, who typically will introduce him or herself to the group. DCF will be there. Typically the DCF social worker or supervisor or both will be there. And the hearing officer will again introduce herself and then walk you through what the process would entail. It's similar to a court trial, minus the jury, minus the courtroom and the judge, but each side gets to put on evidence. The hearing officer will start by also introducing all of the documents that they're supposed to consider into evidence. And so if you have documents, you need to make sure you get that to them beforehand. And in our next video, we'll talk about how to prepare for a substantiation hearing. So they'll go through the list of documents to make sure everybody's in agreement as to what's supposed to come into evidence or what they'll be reviewing in completing the hearing. And then DCF will start with its case. DCF has the burden of proof in substantiation hearings, and therefore they go first. Kind of like, again, on TV where you see the prosecution goes first and then the defense goes second. And so the DCF social worker will be testifying as the investigator. Sometimes it ends up being the supervisor if the worker's not available or no longer works for the Department of Children and Families. And so after that person testifies, the defense or yourself, whoever is appealing, gets to actually cross-examine the social worker. And it's important to make sure that you focus on any inconsistencies that the social worker might have had, or if there were things that they missed or other information that they just failed to include in their investigation. So this is where the attorney comes in and is very helpful, because we are trained on how to pick up those inconsistencies, especially legal inconsistencies, and also how to cross-examine a person effectively. And so after you've asked your particular questions, then DCF gets to what we call in lawyers' terms to rehabilitate their witness, fix anything that might have come out. And this goes back and forth, and you'll get another turn, and it'll go back and forth until both sides are done with that particular witness. DCF may call other witnesses, and you want to make sure that you get notice of who the other witnesses are. And then again, for each witness, both sides will ask questions. DCF goes first, the appellant goes second, and it just keeps going until no one else has any questions. Once DCF is finished with their case, they rest. And so rests mean they have no other evidence that they want to produce. You then, as the appellant, have the opportunity to produce your own evidence. You can call your own witnesses. One of the things that you want to do is let your witnesses know that they can't sit in while everyone is testifying. They can only come into the room when they're testifying, and when they're done testifying, they leave. And so the process is kind of flipped. At that point, when you put on your evidence, you ask your questions, and then DCF's attorney gets to ask their questions of your witness. And again, it goes back and forth until both parties are done. The hearing officer sometimes may ask a question of any of the witnesses, and if they do, both parties get a chance to do any follow-up, any rehabilitation if necessary, and then the witnesses are released. The only people that stay in the room the entire process is the hearing officer, yourself, if you're represented by counsel, your attorney, DCF's attorney, who is called a principal attorney. It's the in-house counsel, not the person or the attorney that you might see in court. Those are called the attorney general, assistant attorney generals, and also the DCF social worker and supervisor. They stay in the hearing the entire time. Once all of the evidence is presented, the hearing officer will conclude the hearing. I should also note that they will tell you in the beginning that the hearing is being recorded. So if it's in person, they normally have a little digital recorder that's recording the whole hearing. But now that we're doing things virtually, because of the quarantine, they will let you know that they're recording the particular hearing by video, whether it's by Teams, and I think typically right now they're using Teams, but if it's any other platform, they will tell you that it's being videotaped, which is a good thing because you might need the transcripts later on if you want to appeal. So after the hearing is concluded, the hearing officer will let you know that they will render their decision in writing. They don't tell you right then and there who won or who lost, but they will give you that in writing. They have up to 30 days, depending on the type of case, to be able to render a decision in writing. They will send you that decision by mail. Sometimes for the attorneys, they will send it by email, but nevertheless, you'll get that decision in writing. If you get the decision and DCF and the hearing officer decided that there wasn't sufficient grounds, they would reverse the decision, which means that they will find that there was not enough to substantiate abuse or neglect or whatever was the finding, and therefore your name and record is cleared on that particular matter. If they uphold the substantiation, that means that they are, in their opinion, there was sufficient grounds to make the decision of abuse or neglect, and therefore the substantiation stands. At that point, you can appeal, and again, there's a certain timeline, but you can appeal to the Superior Court, in which a judge of the Superior Court will hear the matter, and they're not going to relitigate the facts of the case. They're just going to decide whether or not the hearing officer, their conclusions are consistent with the facts and that it wasn't clearly erroneous. They didn't just make up something and it had nothing to do with the facts. And so at that point, if the Superior Court decides that yes, DCF had enough information to be able to make that decision, and the hearing officer's decision to uphold the substantiation was actually clear and it's actually accurate, or not erroneous, I should say, then you have the ability to appeal to our appellate court. If they accept the case, they again do the same type of review the Superior Court would do based on the law and based on the facts. And if the appellate court upholds DCF's decision, then you can appeal to the Supreme Court of our state. If they accept the case and they look at it, they can either decide to uphold it or that the decision was clearly erroneous and reverse all of the rulings prior to. So it can be a long process. You make the decision as far as how far you want to go. But the key takeaways from this is to understand that there is a process. You don't have to live with whatever the decision that DCF made. Secondly, when you go into this particular hearing, expect that there will be a lot of back and forth and an opportunity to actually question the decisions that were made and the process that was used to make the decisions about your family. And lastly, just because the substantiation hearing in and of itself doesn't rule in your favor, you do have the right to go up as far as the Supreme Court of Connecticut, if they accept the cases, because it's up to them to accept the case, and then wait for that final decision from our Supreme Court. And so hopefully this has been helpful to you in understanding what your rights are around a substantiation hearing. If you haven't already, please subscribe to our channel and like this video. And also share it with other people who might just have questions about it. And please feel free to call our office if you need help with a substantiation hearing and you want us to represent you. I like fighting them. I like fighting decisions that I think are clearly erroneous, and just advocating for people, because these decisions can have a lifelong impact on your life. So take care, and we'll see you next time.